67 files.
And then the others?
For accused number 3, it's over 700.
Right, and then the others?
Those are the only.
So in jointly, it's how many photographs?
It's in excess of 6,000.
Right. As any person with fairness can see, these are thousands and thousands of photographs. And the explanation given by the state is conceivably correct on the basis that it was only during the recess period when the court had recessed because there had to be preparation by accused number 1's counsel to prepare. Then that preparation took about, for a cross-examination, took about 4 months, 3 weeks. And it is during that time of preparation when the state alleges that it was trawling through these thousands of photographs that it came across evidence of the remainder of the photographs, which in perusal thereof the state thought it advisable to use that evidence. And the gravamen of the matter is that all the accused counsel had this evidence, all of them. They are not taken by surprise. All of them, they had this evidence. This court remembers it had to adjourn for about 2 weeks when all the counsel said they wanted to peruse the photographs. So the state is arguing that this evidence is relevant, and the defense is arguing the contrary, that this evidence is not relevant. It is new evidence. And the premise of the law is as follows. Irrelevant evidence is inadmissible. No evidence as to any fact, matter, or thing shall be admissible which is irrelevant or immaterial and which cannot conduce to prove or disprove any point of fact at issue in criminal proceedings. And I'm reading this from the TOEIC, if you want to read it, page 2422b. The meaning of relevance. The relevance of an item of evidence refers to its logical tendency to show or indicate the material fact for which the evidence is offered. See in this regard the case of R versus Katz, 1946 AD 71 to 77, where Watermeyer, who was then the Chief Justice, approved the following definition by Stephen Digest of the Law of Evidence, 11th edition, 1930, Article 1. I repeat, the word relevant meant that any two facts to which it is applied are so related to each other that according to the common sense of events, either taken by itself or in connection with other facts, proves or renders probable the past, present, or future existence or non-existence of the other. Here we're talking about photographs. So we're not talking about hypothetical evidence. We're talking about material photographs. And as I listen to the argument of the defense of the accused is not affected in essence. In other words, the defense of the accused remains the same. They know nothing about the so-called alleged murder of the deceased They were not there at any time. They know nothing about that. So the defense remains constant and consistent. So the prejudice, if any, is it has been tendered at a later stage, but the state has proffered compelling and compellable evidence that this evidence, although it can be categorized as new, it has relevance to this case, and it is related to all the evidence that has been led in this case, that of photographs. And we talked about the photographs being about 5,000 or 7,000. And there is no ambush, because according to Mr. Baloyi, on behalf of the state, 3 weeks or so, the same photographs which were discovered by Mr. Malone was tendered to all the defense counsels, and they were advised that the state intends leading that evidence. So let's see if this evidence is now taken out of a hat like a rabbit of a magician. According to Baloyi, it was tendered, there were discussions, there were postponement of the discussions, and when I listened to the two parties, they met, but somebody was saying, no, you're lying, the other one's saying, no, it's not true, etc., etc. But the fact of the matter is, no person was ambushed. Okay. In the case of R versus Mpanza, 1915 AD, 343 to 352 to 3, and R versus Torpedo, 1920 AD, 56 to 62, the learned judge just said, I paraphrase, clearly then, questions relating to relevance may not be resolved by resorting to juridical formulae, but rather to reason, common sense, and for Schreiner, the former judge of appeal, who was supposed to have been our Chief Justice, but because of politics, he was never appointed, like a friend of mine, whose name I shall not mention. Clearly, the question relating to relevance may not be resolved by resorting to juridical formulae, but rather to reason and common sense, and as observed by Schreiner. It is based upon a blend of logic, experience, lying outside the law. Okay, now the prosecutor has a duty to bring all the evidence which they believe affects the adjudication of the case. Some 2, 3, 5 months back, I had reason in this court to tell you about a case. I just forget the citation, but I'll give you the facts. Where the SCA, 5 judges of the SCA were adjudicating a matter on argument at the SCA, and at the last minute, the state applied for a postponement in order to apply to reopen the state case because they had found certain relevant evidence. Even at that late stage, the SCA, 5 judges, said, we will grant the postponement, we will grant the reopening of the state case. The only question was whether, should we do it, because that case was in the regional court, should we do it in the regional court or should we do it in a high court? But the principle has been established in our law that if the state has cogent, reasonable, admissible evidence, and it has occasion to require it in the proving of a case, it is entitled, in terms of the law, not Ratha, in terms of the law, to do so. And I take comfort in the duties which the state the prosecution rather, is national legislation in the National Prosecuting Authority. 3. Two sections of that act are relevant for the present purposes, namely Section 32 and Section 26.6. 1A, a member of the prosecuting authority shall serve impartially and exercise, carry out, or perform his or her powers, duties, and functions in good faith and without fear, favor, or prejudice, and subject only to the Constitution and the law. And there is further the authority of the Code of Conduct for members of the National Prosecuting Authority in terms of the Government Notice R 1257, in Government Notice 33907 of 29 December 2010, where the following is said. Independence. The prosecutorial discretion to institute and to stop criminal proceedings should be exercised independently in accordance with the prosecution policy and the policy directives, and be free from political, public, and judicial interference. Prosecutors should perform their duties without fear, favor, or prejudice, and in particular, they should carry out their functions impartially and not become personally as opposed to professionally involved in any matter. And 2B, they must avoid taking decisions or involving themselves in matters where a conflict of interest exists or might possibly exist. And they also must take into consideration the public interest as distinct from the media or partisan interest and concerns, however vociferous this may be presented. And further, prosecutors, in terms of the International Association of Prosecutorial Standards, which contain the following relevant provisions. Impartiality. Prosecutors shall perform their duties without fear, favor, or prejudice. In particular, they shall carry out their functions impartially, remain unaffected by individual or sectional interests in public and media pressures, and shall have regard only to the public interest and act with objectivity. And the role of prosecutors in criminal proceedings: they shall perform, I repeat, their duties fairly, consistently, and expeditiously. And in the institution of criminal proceedings, they will proceed only when a case is well-founded upon evidence reasonably believed to be reliable and admissible, and will not continue with prosecution in the absence of such evidence. Throughout the course of the proceedings, the case will be firmly but fairly prosecuted and not beyond what is indicated by the evidence. We further refer to the judgment in the Supreme Court of Canada by Boucher in the case of the Queen versus Boucher versus the Queen, 1955, SCR 16. It's a constitutional court case in Canada. The learned judge has this to say, Judge Rand: it cannot be overemphasized that the purpose of a criminal prosecution is not to obtain a conviction. It is to lay before a jury what the Crown considers to be credible evidence relevant for what is alleged to be a crime. Counsel have a duty to see that all available legal proof of the facts is presented. That's a duty on the state. It should be done firmly, fairly, and to its legitimate strength, but it must also be done fairly, and the role of the prosecutor excludes any notion of winning or losing. His function is a matter of public duty with which in civil life or this can be done and none can be charged with greater personal responsibility. It is to be efficiently performed with an ingrained sense and dignity, the seriousness and the justness of the judicial prosecution. Now, this court is persuaded because the state is saying this evidence is relevant and it is connected to the case, and it doesn't materially change, according to the defense proffered by the accused. They pleaded not guilty, and they proffered, during the cross-examination of some of the witnesses, they proffered defenses which range from, we were not there, we know nothing about that, the state's evidence is not correct, etc., etc. Consequently, in the interest of justice, the court admits that the state is entitled to lead those two witnesses if it so desires, and the application is acceded to. Yeah.
abamile kade bephendula kusona isicelo esiqhamukile ke siqhamukiswa ithimba noma yebo ithimba labashushisi ke lapho ke bayanodaba ukuthi babuzeke imibuzo noma balethe ufakazi obusha ke maphicelezi nezithombe lezi ke kade bekhulumile ngazo ithombe zomsolo oqaza osibili futhi nosithathu ke lapho ke kade babala khona ukuthi ithombe eziyishumi nesithupha futhi uma ngabe ziphelele ke futhi ke kade kwithombe eziyi-19 ke kepha kummelweni ke namuhla advocate mnisi ke akunqaba thizeni ke lapho ke ithimba labashushisi likhulume ke ngodaba lokho leyithombe ngoba ke basho khona ukuthi bonake ubrigadier Kinda kumele akumele ukuthi ufakazi ke lo yena ke olethe ufakazi bomphecelezi malana nodaba leyithombe ke lezo ke laba ke bekhuluma khona kepha bathi ke kumele ukuthi kube abantu ke laba kade bekhona ke ngaphakathi kwelekole lakhaya noma ngaphakathi komuzi ke bekhona ngelanga lesigameko kumele kube yibona ke abathela imali nendlela noma manje lesikhangiso ke salomuntu othizeni noma ke abantu kade bangena ke kulela khaya ke leliyana ke futhi ke basho khona ukuthi kade khona ke uchwepheshe lapho kade asebenza malana nodaba leyithombe phecelezi kade akhona ngaphambi kungesankantolo ufakazi bakhe ke lapho ke futhi umuntu othuleke ithombe lezo basho njalo ukuthi ade ku warrant officer eNdlovu ke lapho ke futhi ade asebenza phecelezi no sergeant Mabasa ke lapho ke futhi ade kuyibo abantu kade bethula ufakazi beyithombe lezi ke lapho ke futhi nommeli wesibili ke wanqaba ekuthizeni ke malana nodaba lolu ithombe lezi ekuthizeni bazijobelele ukuthi kungani bengalethile ufakazi malana nezithombe lezi ke ngesikhathi lesi kade ihlaka ithimba noma ihlangothi labashushisi ke lapho ke kade lehola ke imibuzo makade behamba phambili buza ke imibuzo kufakazi ukuthi kungani kumele ukuthi bamele isikhathi lesi ke lapho ke so ukuthi babuze manje malana nodaba loyithombe ke lapho ke babuya futhi basho khona bathi abazi ukuthi ithombe iqhamuka kuphi ucingo lwakabani noma futhi ilanga lakhona batholakala kuphi futhi bathi asiyazi indlela kade nitshangakala ngayo ke ngomnyaka 2014 futhi ngelanga lesigameko ke futhi kungani ngaphakathi kwethombe zonkana lezi kade zikhona ke ngaphansi kumibukiso sekukuthi lethombe lezi kade bengakhulumile ngazo ke lapho ke kepha kungakathi kade bebeke eceleni bengakhulumile ngazo ngesikhathi lesi kade behola ufakazi babo noma kade behola ke ithimba lofakazi babo ke lapho ke babuya futhi bakhuluma malanga phecelezi nodaba lokuthi kade khona umuntu othizini lapho ke sithi uchwepheshe osebenza ngokwenza uqhathanisa phakathi kwendlela umuntu abukeka ngayo ke lapho ke futhi akhuluma nokuthi ithombe lezi ke bathi ithombe iqhamuka ngaphakathi kuma cellphones wenu noma kumakhala kukhuni benu ke lapho ke futhi babuya futhi basho khona njalo ezinye ithombe zakhona ke ziqhamuka ngaphakathi kwama SD card ke lapho ke bathi futhi kade benqaba ke ithimba leni ithimba labameli ke lapho ke ekuthizeni bakhulume phecelezi noma kulethe ufakazi ke obusha ke phecelezi nodaba lolu kwele ithombe ke lapho ke manje isinqumo senkosi enkantolo ke naso siyasho sihambisa sithi sona ke sihambisana ke nethimba labashushisi ekuthizeni ke udaba lolu ke lokuthi baphinde bavusele icala futhi ngokuthi babuze ke imibuzo ke noma bahole lobufakazi obusha ke ukuthi ithi inkosi enkantolo kwamele ukuthi lokhu kwenzeke ke ngoba babona ukuthi lapho ke kubulungiswa futhi bungaphansi bobulungiswa bezomthetho ke ekuthizeni ngabe ithimba labashushisi lifisa ukuthi ujobelele ke udaba lwalo ke lapho ke nokufamelana nofakazi obusha ke kwamele lokho kwenziwe ke futhi ngoba kungaphansi kwezemthetho futhi wakhuluma khona njalo lapha kade enza ke sibonelo khona ke mala nethimba lenkosi zenkantolo ade zihlezi kwicala ke lapho ke lathi khona kade khona ke inkulumo efana ngamashina lena esityola ke njengamanje ekuthizini lapho kade ihlangwe ithimba ke noma ihlangothi ke labashushisi kade lifisa ukuthi ke lapho liphinde libuyiseke icala lalo ke futhi mana nokufakaza akhe likhethekile ke lapho ke futhi yasho ukuthi nakule licala iyahambisana nenkulumo elethiwe lapho ke ithimba labashushisi ukuthi balethe ufakazi obushake phecelezi malana nodaba lwezithombe.
Yes.
As the court, please, my lord, the state will be calling Warrant Officer LT Ndlovu. He was delayed this morning, my lord. He's traveling from Middleburg and he's just returned from leave. He just relayed the message that he's about 30 minutes away. If we cannot take the long adjournment at this point and resume it at 2.
At 2, okay, fine.